Yep. Okay. Go!
Will you hand me my screen box?
Now go.
Noriko Roberts versus Louis Belgio, commercial roofing specialist, and Old Republic Insurance.
Your Honor, Brian Grantham on behalf of the defendants.
Okay.
Michael Warner on behalf of the plaintiff.
All right. So this is an auto accident case. Is that correct?
Yes, Your Honor.
Okay. Plaintiffs, I'm ready to hear from you.
Your Honor, I think it's defendant's motion that we're here for.
I'm sorry. The motion isn't listed on the.
Oh.
Okay, go ahead. What's the motion?
There's two motions, Your Honor.
Yeah. Your Honor, we have two motions pending. We have a motion for summary judgment as well as a motion to strike part of Ms. Roberts' testimony as well as sanction her counsel for improper conduct during discovery.
Okay. Is the motion for summary judgment depend upon the motion to strike, or can they independently be considered?
They can independently be considered, Your Honor, but they're somewhat related, and so I was going to argue them simultaneously, if that's okay with the court.
That works.
So, Your Honor, this is a 3-car accident case, and this is generally the diagram of the accident. The large commercial truck you see was driven by my client, Mr. Belgio.
I see your heading. You're heading, so you got to go down to the next one.
So, a 3-car accident. This commercial truck is Mr. Belgio's truck. He was making a left-hand turn. Vehicle 2 here is driven by a gentleman named Mr. Pitts, who is not a party to this accident. Vehicle 3 here is Ms. Roberts' vehicle.
Okay.
Mr. Pitts testified that the impact between his truck and my client's truck was at the very rear of my client's commercial vehicle where he had a forklift attached. There was no damage to Ms. Roberts' vehicle whatsoever in the accident, and she testified as much. The photographs taken from the scene confirm that as well. Ms. Roberts has repeatedly said that Mr. Pitts was speeding and that caused the accident. This is a renewal action. In the original action, she said that defendant Pitts was traveling at an excessive speed and failed to maintain his lane. She also said that he failed to properly maintain his lane and had improper regard for the speed of his vehicle. On the right side, there's a record where she lists the approximate speed of Mr. Pitts' vehicle at 60 miles per hour.
Making a left turn with a tractor trailer?
No, ma'am. I'll go back to the diagram. Mr. Pitts is right here at vehicle 2.
Okay.
My client is Mr. Belgio, who's making the left-hand turn.
Okay.
Mr. Pitts, you can see left about 160 feet of drag when he stopped.
Okay. All right.
So she wrote that Mr. Pitts was going about 60 miles per hour in the lane to her left. She testified under oath that he was speeding. I asked, do you remember if you alleged that Mr. Pitts was speeding excessively? She said, yeah. Okay. And I said, so in June of 2021, did you in fact think that Mr. Pitts was speeding excessively at the time of the accident? Ms. Roberts testified, yeah, I think he was.
So who's okay, if Mr. Pitts was deemed to have been or alleged to have been driving 60 miles per hour, and there doesn't appear to be contact between Mr. Pitts. Am I missing something? Mr. Pitts' car seems to be headed to contact the tractor trailer from Belgio, and Ms. Roberts' vehicle doesn't have any visible damage.
Correct.
I'm missing something. What's the proximate cause?
That is actually going to be part of the second motion that we filed, Your Honor.
Okay.
So Ms. Roberts admits that Mr. Pitts caused the accident. I asked her if Mr. Pitts hadn't been speeding, there wouldn't have been an accident, would there? She said there probably wouldn't. There probably wouldn't have. So that's her testimony. Now, in her complaint with respect to how the accident happened, what Ms. Roberts alleged in her complaint was that my client makes a left-hand turn. It caused Mr. Pitts to slam on brakes. She alleges that part of Mr. Pitt's vehicle struck her car in the accident, despite the fact that there was no damage to her car. So that gets into my second motion, which is our motion to strike testimony and to sanction her counsel. During, I put Miss Roberts, excuse me. Miss Roberts repeatedly testified that her car was never struck by Mr. Pitt's truck or the trailer he was hauling. She repeatedly testified that only the tools from Mr. Pitt's trailer hit her car. She gave this testimony even while looking at documents which said Mr. Pitt's vehicle struck hers. We took a break during the deposition, and her attorney told her to change her testimony. So this is testimony that Miss Roberts gave. I asked.
Okay, so slow down.
Sure.
So my theory on attorneys and candor to the court is that we only need to be sworn in once, which is why when attorneys come before me and they say I stayed in my place, I'm relying on the oath they made when they were first sworn in as members of the bar. That carries them throughout their career. So you're stating that an attorney did something improper that would have violated the canons of practice by advising his client as to how to testify. Now, how do you know that happened?
Because Miss Roberts testified that happened.
Okay.
So during the first part of her deposition, I asked her, no part of Mr. Pitt's vehicle or trailer ever made contact with your car. Is that correct? She said, right. And I said, the only impact was some of the tools from Mr. Pitt's trailer hitting your car. Is that correct? She said, yes. As a matter of fact, she looked at this document where her own handwriting, she had written, an 18-wheeler pulled out in front of me, causing the car behind me to struck me. And I asked her about that. And I said, but the car behind you didn't hit you. It was just the tools, right? Yes. So she has said several times before we took a break, no part of Mr. Pitt's truck or trailer hit her car, only the tools. And she did that while even looking at a document that she herself wrote.
Okay, let me understand, because I don't know why I'm confused. I shouldn't be. So Mr. Belgio is driving the 18-wheeler with the tractor and the trailer that is pulling around to the left.
That's correct. This is Mr. Belgio's vehicle one. Vehicle
Mr. Pitt is in a pickup truck with tools on the truck.
With the tools, he's hauling a trailer with tools on the back of it.
Okay, and it's an uncovered trailer. It's just like a flat trailer.
Like a landscaping trailer, you might say.
Okay, and what type of tools?
He runs a mobile car washing business.
Okay.
It's unclear to me what exact tools there were.
Okay.
But essentially what she has testified is that tools from vehicle 2 here and trailer 2 struck her car, and that's the only impact.
Okay, and then based on the visual appreciation of the vehicle driven by the by the plaintiff, there was no visual damage to the vehicle. Is that what your client is asserting?
Not only is my client asserting that, but Miss Roberts herself testified there was no damage to her vehicle. So that's the pictures show it, and Miss Roberts says it. We took a break, and counsel coached Miss Roberts to change her testimony. I asked her, so your attorney said what to you during the break? Her attorney said, I need to clarify that not only the tools had hit my car, but that the trailer also had hit my car because it's in my paperwork. I said, before we took a break, you told me only the tools struck your car. Then we took a break. During that break, your attorney told you to clarify that the trailer struck your car as well, correct? Ms. Roberts said under oath, yes. Your Honor, under Georgia Rule of Professional Conduct 3.4, an attorney is prohibited from counseling or assisting a witness to testify falsely. The comment 1 to that rule states that you should not improperly influence witnesses, as was done here. Your Honor, counsel had other options if he believed that was the truth. He could have directed her after my examination. He could have shown her complaint and said, well, is this true, or is what you testified true before true? He could have refreshed her recollection. Instead, what he chose to do was improperly coach her testimony. And, Your Honor, I think this is important because at a deposition, a witness is to give testimony the way they would give it at trial. If we were in trial in your courtroom and Ms. Roberts had given the testimony she gave, and then we broke for lunch, and at lunch her attorney told her to change her testimony, that wouldn't be proper and you wouldn't allow that. It shouldn't be allowed in a deposition either. It's improper. It violates Rule 3.4 and it violates the spirit of the Georgia Discovery Statute. So the subsequent testimony should be stricken. Ms. Roberts wasn't confused. She didn't ask for me to clarify any questions. She testified, even when looking at her own handwriting, that was wrong, and in fact, only tools from Mr. Pitt's trailer struck her vehicle. At a break, she was coached to change her testimony, and her explanation for the change was because it was, quote, in her paperwork. So the coach testimony shouldn't be allowed. Counsel's behavior was improper, and he should be sanctioned such that he's disinclined to engage in this behavior in the future.
Okay.
So, Your Honor, we should be entitled to summary judgment on the issue of Mr. Pitt's speeding being the sole proximate cause of the accident. This accident barely happened. Mr. Pitt struck the very rear of Mr. Belgio's trailer. The sole proximate cause here is the speeding that Ms. Roberts estimated at 60 miles per hour. Ms. Roberts said the accident would not have happened but for Mr. Pitt's speeding. And then the coach's testimony should be stricken, and it should not be allowed at trial of this case if Your Honor doesn't grant summary judgment. Those are our motions and argument, Your Honor. Thank you.
All right. All right. So, Mr. Grantham?
That was me.
Oh, I'm sorry. I'm sorry. Looking at the wrong, Mr. Horner.
Thank you, Your Honor. I'd like to address the motion for sanctions first. Little surprised, rare or maybe never being attacked personally, but I'm particularly surprised that in doing so, counsel for the defense would misstate and outright leave out important facts. The first thing I'd like to raise that was inexplicably left out is during the deposition of Ms. Roberts, and granted she was all over the place, but in her deposition, the very first time she was asked about what happened, the very first time she's asked about what happened in the accident, she states that the trailer from his truck hit her car. This is on page 42 of her deposition. Did any part of Mr. Pitt's trailer itself hit your car? This is Mr. Grantham asking her these questions. I think it did. You think it did or it did? Yeah, it did. Okay, that's the first time this comes up in her deposition. Said the trailer hit the car. Now, granted, later on, then she says, no, it was only tools from the trailer that hit the car. And I submitted an affidavit in response, Your Honor. And in that affidavit, Mr. Grantham keeps talking about how I coached the witness, taking it as if it's a proven, established fact. First of all, I outlined pretty clearly the history of dealing with Ms. Roberts on this issue. Every time I met with, talked with, discussed this case with Ms. Roberts before her deposition, and indeed in the first part of her deposition, she always said that the trailer hit her car. And then all of a sudden, to my surprise, in her deposition, she says, no, it's only the tools that hit the car. We took a break. It wasn't initiated by me or Ms. Roberts. And Your Honor, and this is what Ms. Roberts said when she's asked about this extensively by Mr. Grantham. All I said to Ms. Roberts was, I asked her first, I said, Ms. Roberts, did the trailer hit your car or did just tools from the trailer hit your car? She said, no, it was the trailer. I said, well, if that's the case, you need to clarify that because you just testified that it was only the tools. I did not coach her what to say. did not engage in any behavior that was contrary to any ethical rules, nor have I ever done so in my career, Your Honor. And so the only two people, and that's what Miss Roberts said when we come back from the break, and she said that. She said, I was told I need to clarify. And that's exactly what I told her, because she had said it two different ways in her deposition. Again, the first time she was asked this question, she said the trailer hit her car. So it is, that's a very important fact that was inexplicably left out.
Did you think about
I
addressing
get it
this
flies in
on
the face of the
Mr.
idea that
Horner?
this was invented whole cloth by me and Miss Roberts in a secret conspiracy at a deposition break.
Mr. Horner?
So anyway,
Mr. Horner,
yes, ma'am.
you consider addressing this on direct after Mr. Grantham asked the question?
I'm sorry?
I said, did you consider clarifying this on direct after Mr. Grantham finished asking his questions?
Well, that's what I was going to do. But Miss Roberts, just in the middle of her deposition, said, I need to clarify something. When they went back on cross with Mr. Grantham asking her questions, she just out of the blue says that. So yeah, that was my plan to deal with it.
Okay.
But at any rate, the only two parties to the
question
conversation. I'm sorry.
Can I ask just one question that doesn't seem relevant, but it is? What damages are being asserted?
Injuries.
To
Miss Roberts. To spinal injuries.
Okay.
Go
ahead.
So at any rate, that's what I wanted to say about that. I think that's perhaps the most important thing in that exchange is that this wasn't something new. This wasn't something surprising. This was what she had indeed said all along. And I just simply pointed out to her, I said, well, that's what you said. And she then took it upon herself to clarify. So that's the motion for sanctions. And Your Honor, I don't see anything improper about anything that I did. I did not coach Ms. Roberts to say anything. Regarding the motion for summary judgment, there's simply disputed issues of material fact. Ms. Roberts did say, well, this is that the statement that was put on the screen was a statement to her chiropractor that the other vehicle, the other passenger vehicle, not the commercial truck, was going 60 miles an hour. In the initial dismissed complaint that was filed by another lawyer, there were indeed unverified statements about the speed of the vehicle. But regardless of all that, the fact of the matter is Mr. Pitts himself, who is a witness, has testified that he was going the speed limit, that he was going 35. And as we point out in our response to the motion, some of the other facts seem to support that, namely that Ms. Roberts testified that that's about the speed that she was going and that Mr. Pitts was behind her the entire way and never overtook her. So, not only does that sort of tend to corroborate what Mr. Pitts said, it also makes Ms. Roberts, who Mr. Grantham is hanging his hat on her testimony, it makes her an unreliable judge of the speed of the Pitts vehicle, given that she testified it was behind her the entire way.
Okay, question. So, looking at the pictures that show the front and back, presumably, of the plaintiff's vehicle. So, if Mr. Pitts' vehicle never overtook her, where's the damage alleged to have happened?
It's alleged that the trailer of his truck, when he hit the commercial truck, the trailer on the pickup truck jackknifed or did whatever it did and hit her car. That's what she said.
What part of her car?
I'm not exactly sure what part of her car.
So we just really gonna stand on notice pleading in this case?
I'm not sure what you mean.
I mean, has she stated anything more specifically? Because what Mr. Grantham is arguing is that your entire case rests on a person who's not even a party to the case being the sole proximate cause of the damages that cause spinal injuries in this case. The pictures that he's show no visible injuries that I can perceive.
No visible damage, you mean?
That damage that I can perceive, but you're alleging that the trailer of a vehicle moving anywhere between the speed limit, which 35 to 65 miles an hour, did not either made impact with her vehicle and caused her to suffer spinal injuries, or the tools from his vehicle that were in the trailer made impact with her vehicle that caused her to suffer spinal injuries, but he never overtook her, so all of this would have happened behind her.
Well, when the vehicles came to arrest initially after the accident, I mean, they were more or less side by side. I guess I'm not sure what your question is, Your Honor. I'm sorry. There is damage to her car. It's unclear whether there was any. It's unclear what damage, if any, was caused by the trailer in your car. That is true. I don't have pictures of her vehicle prior to the wreck. I mean, it's an older vehicle with other damage on it that is unrelated to this wreck.
Okay, go ahead.
So anyway, getting back to addressing the motion for summary judgment, that's a disputed issue of fact as to the speed of the Pitts vehicle. Mr. Pitts, who is now a witness, not a party, his deposition was taken, and his sworn testimony is that he was going 35. So right away, that's a disputed issue of material fact as to whether he was negligent or not. And even if Mr. Pitts was negligent, defendants have not established that he was an intervening, superseding cause. The officer in this case, the driver of the commercial truck, Bellagio, was questioned about this on page 15 of his deposition, but the investigating officer gave the commercial truck a contributing factor for failure to yield, which is exactly what we're alleging, that he blocked the entire road with his truck.
So he was cited for failure to yield?
Yes, ma'am. Or giving a contributing factor. I don't believe he got a ticket. I'm sorry, I misstated.
Okay, was anybody cited in this case?
I don't believe there were any citations, but the investigating officer did give him a contributing factor failure, but not a ticket, I don't believe. Sorry, I misstated that.
Okay, go ahead.
So to be a superseding intervening cause, it has to be an unforeseeable act of negligence that supersedes your own negligence. And again, first of all, there's a disputed fact as to whether Mr. Pitts was negligent at all. But even if he was, our allegation, this is exactly the kind of foreseeable risk that could have happened by blocking the road, that you would, by failing to yield, that you would block the road and thus cause an accident. And Your Honor, we cite numerous cases about the law on superseding intervening causes. So, and the one statement by Ms. Roberts in her deposition, the one sworn statement, like Mr. Grantham said, she was asked, do you think this would have happened if he hadn't have been speeding? She said, probably not. First of all, as I've established, she's not a reliable witness on that fact. Second of all, that's a but-for analysis, not a proximate cause analysis. And third of all, that doesn't preclude the initial negligence of the commercial truck as being the proximate cause of the wreck.
Okay, was there contact made between the commercial truck and Mr. Pitts' vehicle?
I'm sorry, Your Honor, I'm having trouble hearing.
Contact made between the commercial tractor trailer, Bellagio's tractor trailer, and Mr. Pitts' vehicle?
Yes, Your Honor. Mr. Pitts hit the commercial truck, and then our allegation is that the trailer on the back of his truck jackknifed and hit Miss Roberts' car.
Okay, and was there a was there a traffic control device at this intersection?
No, there wasn't. It was a hill and a curve approaching the place where the commercial truck pulled out. But anyway, those are my main 2 points. That the issues are in dispute as to to what extent Mr. Pitts was negligent, and even if he was, there's an issue of fact and law as to whether or not he was a superseding or intervening cause, which we think pretty clearly under the law.
Okay.
That's all I got.
All right. Anything else, Mr. Grantham?
Yes, Your Honor, if I may briefly respond.
Okay.
So with respect to the damage to Miss Roberts' vehicle, I asked her on page 73 and 74 about the appearance of her vehicle. And she said that all the marks on the vehicle existed prior to the accident. I asked question on page 74, do you see any damage to the back of your car that was caused by this accident? She said, no, I don't see any damages. With respect to whether it was the tools or the trailer that struck her vehicle, she did initially say, I think the back of his trailer kind of hit her on the side. And then as I continued to ask her, I said, do you know that Mr. Pitt's trailer hit your car? And she said, I think it was the things that was on his trailer that flew. And so I asked her to clarify that. And she said, right, because he had some heavy tools. So then I asked her, so no part of Mr. Pitt's vehicle or trailer ever made contact with your car. Is that correct? She said, correct. And so then I said, so the only impact on your car was some of the tools from Mr. Pitt's trailer. She said, uh-huh. I said, is that a yes? She said, yes. And then later I showed her that exhibit that I showed the court. And again, she testified unequivocally that the only thing that struck was the tools and not the trailer. Now, with respect to the coaching issue, on page 74 of her deposition, she says she needed to clarify something. And then on page 75, she said she wanted to clarify and say it was a trailer. And she said it was brought to my attention. I said, question by your attorney. She said, yeah. I said, what did your attorney tell you? And Mr. Horner objected, and we went on. And I said, what did your attorney tell you on page 76? She said, but he just wanting me to like clarify up so he won't think like I'm just saying that the tools just hit my car.
Okay, Mr. Grantham. So let me ask, on page 42 of the deposition, had she said that the trailer from the vehicle hit her car?
She initially said, it looks like on page 46 of her deposition.
Okay.
So actually, okay, page 45, I asked her, was there any impact between Mr. Pitt's vehicle and your car? Mm-hmm. And she said, I don't remember seeing it, but I heard, hear like a bump or something hit my car. And then I said, what did you think it was? She said, I realized that was Mr. Pitt's trailer had swerved and all of his things and belongings and stuff was everywhere. And so I said, some of the things from Mr. Pitt's trailer hit your car. And she said, yes. So then on page 46, she says, I think the back of his trailer it's kind of indistinguishable what she says, but she says, I said, you think Mr. Pitt's trailer hit your car? She said, I'm thinking that was the noise. I said, but you don't know. And she said, when I heard the bump, 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 yeah. And so on the next page, she clarifies and says, no, it was just the tools and not the trailer. So during her deposition, during my questioning, she changes her testimony and she consistently testifies that it was just the tools. She edits her testimony, which she's allowed to do. It's a discovery deposition.
Mhm.
And even when I showed her a document that she had written that says that the trailer struck her, she says, no, that's not what happened. It was tools. And so, as I mentioned in my original argument, and as the court brought up, if opposing counsel thought that that was incorrect testimony, the correct way to fix it is by refreshing her recollection on direct examination. Instead, what happened is counsel spoke with her in the hall and said, hey, you testified that it was only the tools. You should have said it was the trailer. This was not, we didn't come back from a break and Miss Roberts, of her own accord, without any conversation with her counsel, said, you know what, it was wrong what I said. I needed to say that the trailer hit my car, not the tools. She only made that clarification because her attorney coached her to do it. That's the only reason that happened. Now, again, he could have fixed it on direct examination, and then I could have recrossed and we could have gone through that. That's not what happened.
So let me ask one question. So, arguendo, the break happens. Mr. Horner has his client, I guess, away from wherever the deposition is taking place, and he says to her, you might need to clarify your testimony. Is that what you if he says nothing beyond that, is that what you would consider coaching?
Well, we don't have to guess, though, because we know what she said he said, and we know Mr. Horner submitted an affidavit. He says, paragraph 7 of his affidavit, during a break initiated by counsel for the defendants, I asked Miss Roberts whether the trailer from the pitch truck hit her, as she stated to me several times before. She said yes. I then let her know that the testimony she had given made it sound like only tools from the trailer hit her vehicle, not the trailer herself.
Okay.
So we don't have to guess as to what the conversation was, because both counsel and Miss Roberts say that they had a conversation about the trailer striking the vehicle.
All right, go ahead. I'm sorry I interrupted you.
No, that's okay, Your Honor. That's the end of my argument, Your Honor. Plaintiff has made admissions that Mr. Pitts was speeding. If Mr. Pitts weren't speeding, this accident doesn't happen. Plaintiff herself admits that. But to the extent you don't grant summary judgment, I believe the testimony regarding the trailer striking Ms. Roberts' car must be stricken to comport with the Georgia Rules of Professional Conduct as well as the Georgia Civil Practice Act.
Your Honor, since it's very clear what I said and what I did not say, I would really appreciate if Mr. Grantham stopped inventing things that I said that, as we all know, I didn't.
Okay, so I
would appreciate that.
I don't want this to get contentious, because this is a matter of utmost importance. Whenever we talk about an attorney's professionalism and whether they have in some way violated the canons or rules of practice, I take that very seriously. And so I will look at what the affidavits have stated. I will look at the deposition testimony was. I will look at the rule and any notes to the rule before I make a determination about that, because the last thing one wants in the practice of law is to have your reputation tarnished by something of this nature. I was a civil attorney. I know how difficult it is when you have a person testifying, whether plaintiff or defense witness, and they are just all over the place. And so I understand how that happens. In fact, it is the norm. It is the norm as opposed to the exception. So let me look at the rules. Let me make sure that what is being presented, that I fully comprehend what is being presented and what is being argued on both cases, but particularly on the sanctions, because I take that very seriously. So I will make a determination on both of these issues with respect to the summary judgment, with respect to the motion to strike, and with respect to the motion for sanction. Okay.
Thank you.
All right. Thank you. We'll get an order out to you as soon as I have done my due diligence and reviewed all of the information that you've all presented, as well as the written information. Okay.
Thank you, Judge. That concludes my business. May I be excused?
You may both be excused. Thank you so much. You're free to go.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an interpreter.
I need an interpreter when I cannot express myself somehow.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside and this. What is wrong with everybody today? You know what, Miss Reed? We're gonna start bringing people in person. We're gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No case. Trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.